there are medical records, but I don't have them.
Correct.
Which is this?
I don't have them.
Okay.
I can confirm
that we know that they exist. I understand what you're saying, counsel. There should be, but I'm just trying to figure out is there an indication that something happened that would have resulted in medical records?
Yes, Your Honor.
Okay. So I don't necessarily blame the prosecutor per se, but I do think that is something that's extremely relevant to this present litigation. I would like an order.
When everybody says they're not blaming the prosecutor per se, they're blaming you. Anyway, go ahead. No.
You know what, Your Honor, I have no problem going on the record saying I'm blaming Ypsilanti Police Department for not getting the medical.
Well, yeah, you didn't have to say that. It was kind of implied. I get it. I understand.
Yeah, I have no problem with that.
So, okay, how do we rectify it? Because I doubt YPD has them.
And another issue,
have to get another way.
Been discussing potential paths towards resolution, one of which involves a screening, which I will endeavor to set up for between now and the next BCC.
All right, very good. I'll adjourn this out to May 7th, 2020, 9 a.m. Friday.
Thank you very much.
Bond continued.
Thank you.
Court calls the case, People versus Blaine, Townley.
Yes, folks, people.
Good afternoon, Your Honor. Deanna Kelly appearing on behalf of Blaine Townley. Sir, could you say your name?
Blaine Townley.
Thank you.
Right.
We have a request for an adjournment, Your Honor. I had provided a bunch of documentation to another prosecutor, but I think there was a shakeup in the prosecutor's office. So Ms. Feltz didn't have the opportunity to see what I sent, and I would like her to have the opportunity to do that.
All right. And a lot is falling on Ms. Feltz to do, but she's
I'm ready, Your Honor.
more than capable. How much time did you need? You said
I understand the documentation may be medically related to the defendant, so it may take me just a little bit more time. Whatever works for defense counsel's schedule will be fine. 3, 4, 5 weeks, somewhere in there.
Yes,
7th or the 14th.
7th would be great.
7th. All right. I'll adjourn this to May 7th, 2026, 9 a.m. Bond continued.
9 a.m. Thank you, Judge.
Well, I said everything at 9, but a block. You will after that.
Understood. Thank you so much. Nice.
Thank you. Court calls the case, People versus Cyrus, Robertson.
Jacob Kennedy for the people, Your Honor.
Good afternoon, Your Honor. Attorney Amberly, P84377, standing in for the attorney of record on behalf of Defendant Robertson, who should be on the Zoom.
You don't sound confident, counsel.
Yes, ma'am. I'm here.
Where are you? Oh, there you are. All right. Say your name, sir.
Cyrus Robertson.
Thank you. All right. And counsel, you're with the same office as counsel of record?
Yes, Your Honor. Just 1 second. There are 2 Robertsons. I just want to make sure this is, yep, Cyrus is the right one. Okay.
That is correct.
Yes, Your Honor. We are with the same firm.
All right. That's all I wanted to know, just to make sure Mr. Robertson didn't need to give his permission for you to step in. All right. What are we doing today?
Your Honor, the prosecutor indicated that they need time to talk to the alleged victim about a resolution. So I guess they're requesting an adjournment in order to do so.
That correct, Mr. Kennedy?
Yes, Your Honor.
All right. How much time would you need?
Your Honor, we need 3 to 4 weeks on this one.
All right. Without objection, probable cause May 7th, 2026, 9 a.m. or as your invite indicates. Will that work for you, counsel?
Yes, Your Honor, it does.
All right. Fantastic. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls the case, People versus Dustin, Meggison.
Good afternoon, Your Honor.
Good afternoon, Your Honor. Attorney Amberly, P84377, standing in for the attorney of record on behalf of Mr. Meggison, who appears via Zoom.
And Mr. Meggison, can you state your name, please, sir?
Dustin Meggison.
All right. All right, what are we doing on this one?
Your Honor, we are still waiting on the blood lab from MSP, so we're requesting an adjournment until that lab report comes back.
Your Honor, I don't have that yet. I would ask for at least a month, but I expect it might take some time.
Got it. I'll adjourn this one out to May 14th, given the nature of the request. May 14th, 2026, 9 a.m. as your invite indicates. Bond will continue.
Thank you, Your Honor.
Thank you. Court does call the case, People versus Patrick Lay.
Good afternoon, Your Honor.
Your Honor, Michael Vincent on behalf of Patrick Lay. Mr. Lay, step forward, state your name.
Patrick, go ahead.
Your Honor, today's date time for a probable cause conference. I've been informed that we need about 3 to 4 weeks for further discovery, basically video.
Basically video. All right. May 7th, that work?
Your Honor.
May 7th, 2026, 9 a.m. Bond.
Thank you.
On behalf of Dana Fletcher, P41543, could you state your name for the record?
Dana Fletcher.
Thank you. All right, what are we doing?
Your Honor, discovery just recently came. We're asking for an adjournment till either April 30th or May 14th.
Without objection, April 30th, 2026, 9 a.m. Where's your invite indicates. Bond will continue.
Thank you very much, Your Honor.
Thank you, sir. Court calls the case of the People versus Edna Germa.
With people.
Good morning, Judge. Good afternoon, Judge. Christian Quinn, P69483, appearing on behalf of Miss Germa.
Germa, can you state your name, please?
Edna Germa.
Thank you. All right, what are we doing?
I had reached out to the prosecutor about a plea offer, but I hadn't heard back. So I guess we'll just set it for exam. I do have all the discovery.
That is correct, Your Honor. Mr. Quinn did email me this morning. Unfortunately, I've been in 2 different documents today and I was not able to get back to him. I'm comfortable if he wants to set it, we can, or we can continue the plea offer discussion and we adjourn the matter. His choice.
I like options, Judge. We can try for another PCC.
All right, I'll adjourn the matter out to April 30th, 2026, 9 a.m.
Thank you, Judge.
All right, Bond will continue. Thank you, Ms. Germa.
Can I take my tether off?
Oh yeah, that is one other issue, Judge. Just briefly,
What?
Miss Germa has a tether on, but it's a possession charge. She doesn't have any prior history. I think this could resolve.
Is it?
And I do go to.
It's a GPS.
Yes. I'm not
People
gonna go.
Well, I know where to find you. We have to. No, I'm kidding. All right.
It looks like there was a prior failure to appear or a bond violation.
That's what the.
Hang on.
is for.
Oh, I had revoked her bond. How long have you had the tether on? I'm trying to see. Did you have it on from the beginning?
No, I had it on after the second time you signed me out of jail. It was the 11th of March is when I finally got out.
Yeah, I'll tell you what. All right, here's what I'll do. Germa,
Yes, sir.
I'll release you from the tether, but you know how I am. So if you mess up, it's not
You
even
know
going to be a tether. You'll just be sitting.
You know I know. And I'm in outpatient with Don's Farm doing as you told me to.
Yes, ma'am.
Yes, sir.
I don't know if there's a current testing order because you're at Don Farms right now, correct?
They test us. Yeah.
They're
Oh, yeah.
testing
Oh, yes, sir.
because you're in Don Farms outpatient.
Yes. Yes.
But those tests aren't being sent over to community corrections.
Why? I mean, I don't know.
Okay, did you sign a release?
I'm not sure, but I can. They should have.
Okay, you'll need to sign a release to send those over to community corrections. Can we make sure we have testing?
Yes, sir.
That she can, so that she does that release, we can receive them and then to remove them from the
Thank you.
How often should she test?
How often are they testing you at Don Farms?
I've been tested twice since I've been there.
And how long you been there?
Since the
A
11th.
month?
Yes.
So, well, they're really probably once a week, one time per week.
So we go once a week, classes.
Yeah. That's what I thought.
Yes.
Okay, so I'm going to take you off of the tether, Ms. Germa. We're going to enter an order for one time per week testing through Don Farms. You're to complete a release for Don Farms to send the results to community corrections. Got it?
Yes, sir. So I can come up there, get the tether off, and I will go straight to Don's Farm and sign the release.
All right, real good. Okay.
Thank you.
You're welcome. Don't mess it up.
I'm not. I've had enough.
Okay, I'm just telling you.
You scared
Okay.
me straight. Trust me.
I did what?
You have scared me straight.
All right. Well, let's hope I just needed to stick. All
Okay.
right, Ms. Germa, you take care of yourself.
Thank you. You as well. Bye-bye.
Court does call the case. People State of Michigan versus Mary Goldstein. First.
Good afternoon, Your Honor. Rico Neal on behalf of Mrs. Mary Goldstein, who is present via the video system. Mrs. Goldstein, please unmute yourself and identify yourself for the record.
Mary Jo Goldstein.
Thank you. All right, what are we doing?
Judge, I've had an opportunity to discuss this matter both with counsel and with my client. As the court is aware, this is an 11th hour deal for the prosecutor. As such, we would be requesting to reset the PCC and the DPE if necessary. May 7th does work for my calendar.
Hold on a second. This is the 11th hour. Ms. Faltez, is this you again?
Yes.
Why does everybody think that this is really hard for you? See, you guys just don't know her. She's already been through these cases. She has them all sorted out, all sifted. She knows everything about these cases. She's that good.
One challenge is it's so hard for me to be able to talk to people when I'm on the record. So if we could adjourn this so I can have a chance to discuss with defense counsel.
But do you really want to talk to him?
I think I should.
Okay. All right. Well, all right.
I want to talk
we'll
to her, Judge.
All right. What I'll do is I'll adjourn it to May 7th, 2026, 9 a.m., but as your invite indicates.
Thank you, Judge.
All right.
Permission to appear
Fine.
via Zoom as well?
You'll have to send the forms in.
Will do.
I'm not going to have a problem with it. But... Okay.
Will do, Judge. Thank you very much.
Right. Thank
Have
you.
a good day.
You do the same. Court calls the case of the People versus Hunter Hurtline.
Thoughts to the people.
And good afternoon, Your Honor. Megan Stammel on behalf of Mr. Hurtline, who I see present on Zoom. I'll ask Mr. Hurtline to state his name for the record.
Hunter Hurtline.
Okay, thank you. All right, what are we doing?
Your Honor, in what appears to be a theme this afternoon, we are requesting just some additional time so that we can get up to speed with the new prosecutor on the case in the hopes of reaching a resolution. I would ask for either April 30th or May 14th, whichever works best for the court and the people.
Thank you, Bridget.
We'll adjourn the matter to April 30th. 2026, 9 a.m. Or as your
Thank you.
invite indicates. Don't let her fool you. She knows everything. I'm telling you.
Oh.
All right. All right. You guys take care. Bond continue. Court calls the case People versus Connor Karns.
Your Honor. Good afternoon, Your Honor. Richard Lippett on behalf of the defendant, Connor Karns. He appears via Zoom as well.
Okay. Oh, there he is. Sir, state your name.
Connor Karns, good afternoon, Your Honor.
Good afternoon, sir. All right. What are we doing?
Your Honor, the defendant would like to have this matter set for a preliminary exam.
All right. Is all discovery complete?
It is not, but we do not want to let that delay the preliminary exam.
Well, what discovery are we waiting for? We typically don't set it.
I
until we have all-
I haven't received a copy of the police report yet, or so. But
You don't. But do you have anything, counsel, on this, or?
I do not.
Okay, then I'm not setting it, but
We did get an appearance from Mr. Lippett to our office a week ago.
so he sent it in for whatever reason. Discovery didn't go out to him.
I'll make sure it's.
All right. All right. I don't want to delay it either, but I'm not going to set an exam until I make sure that discovery is at least minimally complete. So I can adjourn it out a couple weeks, counsel. Let them get that over to you. You're going to send that on its way to him, right?
Yes, sir.
All right.
Great. All right. What day would that be, Your Honor?
I can do the 23rd or 30th, whichever works better for you, counsel.
The 23rd, Your Honor.
23rd. All right. I'll adjourn this matter to April 23rd, 2026. I set it at 9, but it'd be sometime in the afternoon. For you guys.
Sure. Thank you very much, Your Honor.
All right. Thank you. Bond will
Yep.
continue. Thank you. Thank you,
Yeah,
Mr.
bye-bye.
Karns.
Thank you, Your Honor.
Court calls case People versus Daquan Mallett.
Good morning, Judge. On behalf of Mr. Mallett, Attorney Nicholas North, PA 6482. Mr. Mallett, please unmute and state your name.
Daquan Mallett.
All right. And what are we doing?
I suppose we're setting an exam. I've asked about an offer. I haven't received any word back.
Is this one or?
I'm sorry, I couldn't hear what you just said.
Well, I'm trying to figure out whether there's been a switch of prosecutors on it. That's maybe why you haven't received a response, or if it's a circumstance.
So
that
there has been a switch in the prosecutors. I sent an email to that person too. To those people as well.
When did you send it?
It was earlier today. 1 second.
Oh, okay. That's not going to happen. So, because the assigned prosecutor was in another court handing on another docket. So what I'd prefer to do in those instances is I'm going to adjourn it out a couple of weeks. I'll give you the 23rd or 30th. Allow a response to go rather than clients heading headlong in exam.
Okay.
Which day would be better for you, Mr. North?
The 23rd is fine.
I'll adjourn this matter to April 23rd, 2026, 9 a.m., but your case will be set in the afternoon. Bond will continue. Thank you, Mr. Mallett.
Thank you.
Court calls the case People versus Terry LaVon Williams.
Raymond Cook.
Yes. Oh. Oh. How you doing? What's your name? Terry Williams. Okay. Mr. Williams, we got a slight problem. The gentleman that I was just speaking to is reassigned to handle your case, Mr. North. All right. We've got contact information, whatever. He's back. Oh, he's back. So I was going to pass it and try to get it back here. All right. I've called the case of Terry LeBron Williams. Mr. North, you were just assigned by the MAC office.
Correct. It just happened about 45 minutes ago. That's why I logged off. I just forgot, but yes, I'm back. Thank you.
No, it's okay. It's all right. We got your back. Mr. Williams was upset, but I wasn't. No, I'm kidding. All right. State your name, sir. Terry Williams. All right. So you'll be handling this. We put his last case out till what day?
23rd.
23rd. All right. So here's what I'm going to do, Mr. Williams. Mr. Norris just been assigned to your case. I'm going to set your case out to the 23rd.
Okay.
Okay. Next time they're back, and then we can deal with it from there. Okay. Sounds good? All right. Bond will continue. Thank you, sir.
Is this going to be another 2 p.m. case too as well, Your Honor?
Yeah. Oh, yeah. No, your cases will be putting your cases together as best we can.
Okay. I appreciate it.
All right. Thank you.
Yep. Bye.
Bye-bye. Court does call the case of the people versus Alexander Sanchez Garcia.
Good afternoon, Your Honor. Jason Kennedy for the people.
Good afternoon, Your Honor. Nicholas Monterez on behalf of Mr. Alexander Sanchez Garcia, who is present on Zoom.
Sir, can you please state your name?
Yeah, Alexander Sanchez Garcia.
Thank you. All right, what are we doing?
Your Honor, through diligent work and effort with Mr. Kennedy, I believe we reached a resolution. That resolution is going to have to take place in circuit court, so I don't want to step on his toes, but my understanding is that we are entering a conditional waiver this afternoon.
Well,
and that is correct, Your Honor. The conditional waiver would be that the defendant, upon waiver and upon first pretrial at the circuit court level, would be entering a plea to an added count 5 of criminal sexual conduct, 3rd degree, the 13 to 15 prong, and that would take place under the Holmes Youthful Jury.
Is that a correct statement?
That is a correct statement, Your Honor, and I've gone over with Mr. Sanchez Garcia his right to an exam, and he has elected to waive in order to take advantage of that offer.
All right. Mr. Sanchez Garcia, if you can unmute for me, please. Sir, you understand that you're waiving right to a preliminary examination?
Yes, Your Honor.
You understand that that's a proceeding where the people would have to show by the standard of probable cause that the offenses alleged were committed and that you committed them?
Yes, Your Honor.
You understand you will not have that hearing and that you'll proceed to circuit court for further resolution?
Yes, Your Honor.
And people do also waive their
Yes, Your Honor.
All right. Preliminary examination having been waived, defendants bound over to circuit court on all 4 counts. That's what I have.
It should be 4, yes.
Yeah. All right. Counsel, you acknowledge receipt of the information, waive its reading, and your client stands mute at this time?
Correct, Your Honor.
Defendant having waived formal reading, standing mute to all 4 counts. Court will enter not guilty plea. Pretrial will be set for June 1st, 2026, 1:30 before Judge Hamoud.
Thank you, Your Honor.
Thank you. Bond will continue.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Okay. You're welcome. And Mr. Kennedy, well, might have to prepare a new one. I don't see one in here. I don't see that we have one. All right. Court calls the case, people versus Angelo Massa. No.
Good afternoon, Your Honor. For the record, Brendan Dabalski appearing on behalf of Angelo Massa, who's in my office, seated to my right. Sir, what is your name?
Angelo Massa.
All right. Very good. All right. What are we doing?
Your Honor, as you know, today's date and time set for a PCC. Unfortunately, we're awaiting the blood results in this case. At this point in time, I've spoken to the prosecutor. She understands that. We're going to need another PCC date. I know that's kind of the theme for all the cases this afternoon, but unfortunately, in our case, we have to have another PCC date.
That is correct.
Yes. Waiting on blood. Probable cause May 7th, 2026.
One
9
other
a.m.
issue, Your Honor. I'm sorry.
Yes.
I also spoke to the prosecutor and I indicated that my client had a pre-planned trip to Florida, April 19th through the 25th. It doesn't appear that she has any objection to it, but ultimately I'm asking Your Honor to allow my client to take part and be able to attend that. That's with his family.
It is my understanding the defendant is on a sober link with 2 times a day testing. As long as he continues to test during his trip, I don't have an issue with him going.
Okay.
Or
Yes,
doesn't have a problem.
All right. I'll indicate that. We'll do a bond for him. Defendant may travel to Florida. Your travel dates?
April 19th
Sir.
through 25th. Actually, he's coming back late on the 25th, so probably April 19th through the 26th, Your Honor.
Okay. April 19th through the 26th. I'll permit travel to Florida.
Thank you, Your Honor.
I don't know why people go there, but to see that mouse. I don't like the mouse. Okay, that all aside, I get
Thank you,
trouble
Judge.
every time I say it. Donald Duck's my guy, but we'll deal with that. All right.
Thank you, sir.
Thank you. Bond will
Thanks, Judge.
continue.
Have a great
Thank
day.
you. You too.
Thanks.
Court calls the case. People versus Emmanuel Uduchukwu.
That was
I
very
know
good,
I'm
Your Honor.
all wrong.
You did a great job, Uduchukwu. Yeah, that's it.
I did?
Yeah.
Oh, I'm pretty proud of me. Okay.
Jacob Kennedy for the people, Your Honor.
Joy Mohammed on behalf of Samuel Uduchukwu sits to my left here in my office. Emmanuel, I'm sorry, not Samuel. Emmanuel, please state your name for the record.
Emmanuel Uduchukwu.
All right.
Okay, what are we doing?
Your Honor, we have a couple of issues that we just want to bring to the court's attention. I just received a lot of the digital discovery today here, and I did have a chance to go through it, at least do a preliminary review of it. And so at this time, I'm going to ask for, and I've asked the prosecutor in writing already, for a copy of the medical reports for this case. She has stated that she doesn't have them. I do think that given the nature of this crime, that medical records of the victim are relevant and important. And I'm not sure why PD did not get those.
Okay.
So I don't necessarily blame the prosecutor per se, but I do think that that is something that's extremely relevant to this present litigation. I would like an
When
order.
everybody says they're not blaming the prosecutor per se, they're blaming you. Anyway, go ahead. No.
You know what, Your Honor, I have no problem going on the record saying I'm blaming Ypsilanti Police Department for not getting the medical.
Well, yeah, you didn't have to say that. It was kind of implied. I get it. I understand.
Yeah, I have no problem with that.
So okay, how do we rectify it? Because I doubt YPD has them.
And another issue
have to get another way.
Further compounds, this is a case that is about 2.5 years old as well. So
this case,
yes, Your Honor.
Oh yes, we're going to get into that. The fact that my client
and I was sure that we were. So this is a case that is 2.5 years old. We can certainly have more conversations about those medical records. We can certainly, I don't know if that's something that would end up having to be discussed in motion practice, but we can certainly discuss that further if need.
Well, I guess okay, let me ask this. There could be an issue where there are not medical records, right?
Correct.
Or there are medical records, but I don't have them.
Correct.
Which is this?
I don't have them.
Okay.
I can firmly
that we know that they exist. I understand what you're saying, counsel. There should be, but I'm just trying to figure out is there an indication that something happened that would have resulted in medical records?
Yes, Your Honor. Okay. The initial dispatch was to the University of Michigan Hospital.
Got it. Okay.
That's any indication that they're
gotcha. Okay. So it was to U of M?
Yes, sir.
So the record should be there. All right. So problem is you're not going to be able to get that without a release of some type.
Correct.
And is that something that is going to be feasible in this case? It being
Potentially, it could be. I mean, at its core, I also wonder if this is a case that also isn't just headed towards a resolution, and we may not even necessarily need to go down that path. So I do think that it would be appropriate just to adjourn the PCC for us to have.
I don't have a problem with adjournment. I'm just trying to make sure that the expectations of the court and everybody are kind of the same as what will happen.
As to the release, I don't know.
Don't know.
Okay. But we will do our best to rectify those records not being included in.
All right. Counsel, what was the next thing?
The next thing was, because my client was 16 at the time he was interviewed by Ypsilanti Police Department without his parents present, I would like to have a Walker hearing to possibly have the statements he made to the police suppressed.
Okay, this is getting better and better. Okay. And all right. What you need to do is just file your motion with the request for the Walker hearing. We'll let the prosecutor respond. I'll set it for a hearing if necessary, and then set the hearing, the Walker hearing, if we need to have it. Okay.
Sounds good to me, Your Honor.
Anything else? Boy.
Yes.
Joy Mohammed.
Yes.
Joy Mohammed came loaded for bear. Go ahead. What else?
Pew, pew, pew. My final request, Your Honor, is a bond modification. My client is currently on a GPS tether with home confinement. He has no priors, no capious history, and I was wondering if Your Honor would consider releasing him from his tether at this time.
Do the people have a position? I guess I'm trying to figure out something. This case, and you guys can help me here. This case is 2 years old, or at least.
Correct.
It's charged 5/8 of 25 with allegations occurring back in 2022, right?
23.
Allegedly dating back to 22 based on what I saw. And
what I have is, I'm looking at the complaint and it says 4/1 of 22 through December 16th, 2022.
Sure.
That's what I see as well.
And so the warrant gets authorized 2025. And I guess and then he goes in and goes in for arraignment. And I'm trying to figure out by that point, why was a home confinement tether necessary?
In this particular,
I mean, I kind of loaded up that question, but I'm just, I'm trying to figure out what was it at the time of arraignment that led to, I mean, it could have been just the charges, but I'm trying to figure out, did something occur between the time
of the offense and the time of the arrest?
Yeah, let's say from January 23 up until 25, and then his ultimate arraignment sometime. Was there something that occurred or something that would lead one to believe that?
I don't believe so, Your Honor. And as counsel indicated, I don't believe that the defendant has any criminal history outside of this case. And my position would be that I believe that this is a serious offense, and I do think that the tether should remain. But do I believe the home confinement would be absolutely necessary? No.
And counsel, what you're asking for is the complete removal of the tether.
Yes, Your Honor.
All right. What I'm going to do is I'm not going to remove the tether. I am going to make it just a GPS tracking. So I'm taking the home confinement off.
Okay. So he's free to go to church, school, wherever it is that he wants to go without checking in with the tether?
Correct. Once we get that done, the home confinement portion will go out. It will just be location tracking. There are going to be
There are hot zones. Okay.
Obviously, yes. The hot zones being where the young person goes to school or where
right,
she
but
lives.
I don't know if they, in doing this order, had those hot zones.
Or if they even would still be accurate based upon the case.
Well, right. And I have.
And Your Honor, like I said,
can I just say this? The only thing that was on the order was the name of the individual, and then it just indicates victim's address. But I don't know where that is. Sure. I don't know what was given to community corrections, and it's going to have to be clarified so that that exclusion zone's included.
Sure. Could I prepare the order for the court? That way I can have communication with the victim, get those addresses,
absolutely,
send it to counsel, get it approved.
Yeah, absolutely. You can do it that way, or you can, once you get that information, get that over to Ann. We can make sure that the order's done.
Perfect. Thank you.
Right. So, counsel, what I'm going to suggest is, while I've made that change, that until you receive the order that change is in place, that he abide by it as a home confinement.
Okay. Can I just let the prosecutor know he has not gone to work since his release, which affects his ability to pay for his tether. So if you could please, I know it's 3:34 p.m. If you could please,
I will do my best.
So he could go to work tomorrow. We would greatly appreciate it.
Where does he work? Well,
he works at Sam's Club.
On Michigan Ave?
On Carpenter. On Carpenter.
Carpenter and Michigan Ave, yeah. Okay.
Your Honor, my understanding is that the bond was actually allowed him to go to.
It allowed him to go to Costco, but he was arrested while he was in Costco, and he was trespassed from Costco, and he works at T-Mobile. He works at a T-Mobile kiosk. So he was moved to the Sam's Club location. So, I mean, that's honestly, if we could reconsider.
Hold on, counsel. Hold on. I've got to catch up here, but I'm trying to see. Then I don't know why he. You say he was arrested at Costco?
Correct, where he was working.
That doesn't make any sense to me. And the reason it doesn't make any sense is I'm looking at the order. And it was home confinement, but the provisions were he was allowed to go to attorneys, doctor's appointments, and work. And in parentheses, it indicates Costco. So I don't know why he was that doesn't even make any sense. So here's what I'll do in the interim so that let's do this here so that at least we have something in place that he could know. You said he's at the Sam's Club location at this point, right?
Correct.
All right. I'm going to prepare an order that just is GPS location tracking with, he can go to GPS tracking. And that I'm going to prepare that order so that we have that in place now. So there should not be an issue with whether he's supposed to be wherever he's supposed to be. At that point, then once you get the information, we'll amend that order to just include a hot zone.
Very good.
So today we can do that, get that over there, Ms. Wyman. She's doing it right now. All right, we're going to get the order over there that's going to change his tether. Right? And then we will be changing it again. But that will only be the inclusion of where he specifically can't go, and then he'll know that.
Very good. The PCC the next PCC date, do we need to set that, or should I just wait for a motion date?
No, actually, how soon can you get them? I mean, we can do both on the same date. So how soon would you get a motion in?
If you can give me about a week, 10 days, most 7 to 10 days.
Why don't I do this? Why don't I adjourn this out to the 30th, to April 30th?
The 30th is no, not good for me. I will not be.
That good? Okay, no, that's fine. I can do the 23rd if you want it quicker, or I can do the 7th.
Let's do the 23rd.
23rd?
I'm feeling froggy. I want to come back.
I see that. All right. Probable cause conference I'll set for April 23rd, 2026, 9 a.m. or actually, I'm going to set it for 3 p.m.
Okay.
And then there'll be a motion that will also be set at p.m. And then once we get that, we'll be able to do all of that. I will have his bond continued with the changes in tether that I've just indicated, and we'll prepare that order. All right?
Okay. All right. Thank you, Your Honor.
Is there anything else, counsel, that you want to just try to make me have to do today? My second to the last case of 130.
No, that's all.
That's it? Okay.
If I may, Your Honor.
Yes.
Come on.
Let's this is counsel, please. I'll give you a call. Let's talk about this one. I think that we'll align on some things, and I'll leave it at that.
Thank you.
All right. Thank you.
All right.
You guys have a great day.
You too.
I'll take it off.
No, getting us here.
It was turn.
We don't.
Yeah, defendant is in Zoom.
Okay, court does call the case of the people state of Michigan versus Lucretia Pinder.
The people.
Miss Pinder? Oh, there she is. Hello, what's your name? Oh, we can't hear you. We still can't. You don't have earplugs in or earbuds in, do you? Oh, she does. Let's take those out. Let's try it again. They're still connected. You have to take them out and turn them off.
I can hear you now.
And I can hear you. All right, great. We got it. Okay. And now the great thing is now we can hear each other, but we don't have your attorney. Okay. Do you know where Mr. Zaid is?
I can text him right now.
Okay, why don't you do that? I'll wait a little bit, see if we can figure this out.
Sweet Jesus, come on. I text him and the secretary, so hopefully he'll be joining soon.
All right. Then I'm just gonna, not really at recess, but I'm gonna.
In this courtroom moment, the defendant explains that their work hours were reduced and they are now struggling financially while looking for a new job. The judge listens carefully and instead of reacting harshly, offers practical help. He tells the defendant that before leaving the building, they should go downstairs and ask for Mr. Taylor, who keeps track of local job opportunities, especially for entry-level and unskilled work. After that, the judge moves forward with sentencing. He orders 4 days on the court work program as an alternative to jail and imposes $500 in fines and costs. However, he makes it clear that if the defendant cannot pay the full amount immediately, they can speak with the court staff to set up payment options. This moment shows a balanced approach, holding the defendant accountable while also trying to help them get back on track by pointing them toward employment opportunities. Question: do you think judges should help defendants find jobs, or should they focus only on punishment? If you enjoy real courtroom moments like this, like the video and subscribe for more courtroom stories.
Court calls case People versus Evan Sherbert.
Your Honor, Raymond Cook.
Good morning, Your Honor. Assistant Bug Defender Davi Leva on behalf of Mr. Sherbert.
Sherbert?
Evan Sherbert.
Okay, thank you.
And I'm requesting adjournment so I can review an offer that I received.
Probable cause conference will be adjourned to April 23rd, 2026, 9 a.m.
Thank you, Your Honor.
Bond continued. Court calls case People versus Cecilia Cotton.
Overwater Assistant Prosecuting Attorney for the People.
And Assistant Public Defender Nick Bukovich for Mr. Cotton.
Sir, state your name.
Garcia Cotton.
Thank you.
At this time, Your Honor, we are requesting adjournment to for some further negotiations.
You want 2 or 3 weeks?
Whatever the court deems appropriate. My client is in custody till December.
Yeah, I see that. So, probable cause conference, April 30th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls case People versus Larry Evans.
Overwater Assistant. People.
Good morning, Your Honor. Edward Dukes on behalf of Larry Evans.
Your name, sir?
Larry Evans.
Thank you.
Your Honor, we're asking for an exam.
Sir?
We're asking for a preliminary exam.
Discovery is complete.
To our knowledge.
People have their witnesses available the 23rd. Preliminary examination in person, April 23rd, 2026. AM bond or before Judge Washington. Bond continued.
Thank you, Your Honor.
Court calls case of the People versus Travis May.
Edward Dukes on behalf of Travis May.
May, can you unmute and state your name, please?
Yes, my name is Travis May.
All right.
Thank you, Your Honor. There is some negotiation that's underway. I'd be asking for an adjournment.
Probable cause conference will be adjourned April 30th, 2026, 9 a.m. Bond.
Thank you, Your Honor.
Thank you, Mr. May.
Thank you.
Court calls the cases of the People versus Corey Jones, 2 cases.
Edward Dukes on behalf of Corey Jones.
Your name?
Corey Jones.
Thank you.
At this time, I'd like to set both these matters for exam,
All discoveries complete.
to my knowledge.
Were other witnesses available the 23rd? Preliminary examination in person, April 23rd, 2026, 9 a.m. before Judge. Yeah. That'd be Garwood. It's Garwood. Bond continued.
Thank you, Your Honor.
Thank you. Court calls the case of the people versus Mallett Asadi.
Of order, Assistant Prosecuting Attorney for the people.
Good morning, Your Honor. Veronica Glenn requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Tanazi.
Pardon?
Tanazi, I'm sorry.
I can really, you don't even know who you're, what?
I can't say her name.
What? Tanaza? I can really, right?
Yes, her.
Supervising you?
Yes, her. Mhm.
You're doing a very good job. Don't know her name. All right. I figure this is the last time I'll grant permission to you.
This is.
Well, it has been an absolute pleasure here.
Likewise. Likewise, thank you.
Starting now. Into practices.
And we would like to adjourn in order to submit plea paperwork.
To plea paperwork? You just need. Where's your client? Asadi? On Zoom? Oh, not here.
Oh, sorry. Oh, thanks.
No, it's not your fault. I know whose fault it is, Miss Cannon. All right. You needed to get the paperwork in.
Yes.
Probable cause conference will do April 16,
Or 6.
2026, 9 a.m. next week. Bond can.
Thank you, Your Honor.
Court does call the case of the people versus Keontae Jones.
Good morning, Your Honor. Edward Lucas on behalf of Keontae Jones.
Your name? Keontae Jones.
We'd like a preliminary examination, Your Honor.
Discovery is complete.
My knowledge.
Would people have their witnesses available the 23rd? Preliminary examination in person, April 23rd, 2026, 9 a.m. before Judge Washington. 21st, I'm sorry. Where were we? April 21st are all of these. April 21st, 2026, 9 a.m. before Judge Washington. We're going to have to correct all of those other ones. Bond continued.
Thank you, Your Honor.
Court calls the case People versus Daryl Gardner.
Morning, Your Honor. Raymond Cook for the people.
Ready, Your Honor. Robert J. Kilwell, Judge. I'm on case 0212 FY.
All right, thank you.
Assistant Public Defender Davy Lee, also on behalf of Mr. Gardner.
Daryl, would you state your name for the record?
Daryl Gardner.
Thank you, sir.
Judge, on my matter, I'm set exams.
And Your Honor, on my matter, we are waiving. Mr. Gardner, may I sign the form that I reviewed with you yesterday on your behalf?
No, we wasn't able to sign it, but I'm willing, I'm ready to sign it.
May I sign it on your behalf, sir?
Oh, yes, sir. Yes, sir. Yes, sir. Absolutely.
Thank you.
All right, that's the case of malicious destruction of personal or police property.
It is, Your Honor.
All right. On that case, Mr. Gardner, you're waiving preliminary examination?
Yes, sir.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you could.
Yes, sir.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution on that matter.
Yes, sir.
People also waive their right.
Yes, Your Honor, there was an offer made on that case. And I put that on the record.
Yes, go ahead.
The offer was to waive up to circuit court on people that agree not to add individual.
That is correct, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on the single count.
Your Honor, we acknowledge receipt of the information. We waive formal reading and ask for a pretrial date, please.
Your client standing mute.
Yes, Your Honor.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial in this matter will be set for
April 20th at 1:30 for Judge Simpson.
April 20th, 2026, 1:30 before Judge Hammoud.
Thank you, Your Honor.
Excuse me, what time will it be, sir? What time will the court be? April
For
20th?
for that case, it's going to be April 20th at 1:30.
At 1:30, all right. Thank you.
Before Judge Hammoud. All right, fine, we can continue on that case. And then on the other matter, discovery is complete.
Yes, Your Honor.
People have their witnesses available the 21st.
We'll do our best, Your Honor.
Preliminary examination in person, April 21st, 2026, 9 a.m. before Judge Garwood.
Thank you, Your Honor.
Bond will continue. Thank you.
They're all coming to see you in a couple days.
All right, Bob, thank you.
Thank you, sir. Court calls the case, People versus Walter Peterson, 2 cases.
Raymond Cook for the people.
Good morning, Your Honor. Robert Ellman on behalf of Mr. Peterson on both matters.
No.
Mr. Peterson, can you please state your name for the record?
Walter Peterson.
Waiving on both of these matters.
That's correct, Your Honor. You should have 2 signed forms.
I do. Sir, you're waiving your right to a preliminary examination?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged in each case was committed and that you committed it.
Yes.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes.
Will also waive the right.
Yes, Your Honor. Actually, this is an offer on the record as well.
May.
The offer was made to waive up to circuit court to plead to the felonious assault charge in exchange for dismissal of the retail fraud, as well as there's an option being held open for the defendant to pay restitution on 2 other retail fraud matters in exchange for those cases not being.
Understood. Is that a correct statement, Mr. Elman?
Yes, Your Honor.
All right. Preliminary examination having been waived, defendants bound over to circuit court on both counts.
Your Honor, we would stand mute and waive any formal reading.
And then having waived formal reading, standing mute to both cases. Court will enter a not guilty plea. Pretrial will be set in each matter.
April 21st at 1:30 with Judge Simpson.
April 21st, 2026, 1:30. Judge Kunke.
Thank you, Your Honor.
Thank you. Bond will continue.
I'll talk to you soon.
Court calls case of the People versus Alyssa Arbiter.
Morning, Your Honor. Hannah Mackey, permission to practice under Michigan Court Rule 8.120 under Senior Public Defender Joy Gaines.
Under who?
Senior Assistant Public Defender Joy Gaines.
Oh, Ms. Gaines. All right, I'll let it go. Permission to practice is granted.
Thank you, Your Honor. Ms. Arbiter should be appearing via Zoom.
Ms. Arbiter, can you state your name, please?
Oh, she's muted.
Yes.
Elisa
Yeah.
Arbiter.
There you go. Okay. All right, we're good.
I would like to set this matter for exam.
Discovery complete.
Your Honor, it was my understanding before that the previous prosecutor assigned to the case was going to possibly dismiss this case today. That's why we adjourned it last time. If no media existed to this point, there's still no media. The new prosecutor is on it. They just want to look into the case before deciding anything.
They want to what?
Look into the case to see if a dismissal is warranted or not, or what they want to do.
So what?
Your Honor, the video does not exist. We have the witnesses ready to proceed to exam.
It was relayed to us at last PCC that if no discovery was there, he would dismiss the case. And that's why we adjourned it again instead of setting it that time.
So we're just gonna.
Yeah, so we're setting it now. But there's no video, I'm just,
There's no further discovery of this.
no.
People have their witnesses available the 21st.
Yes, Your Honor.
Preliminary examination in person, April 21st, 2026, 9 a.m. That is before Judge Washington.
Thank you.
Bond will continue. Thank you, ma'am.
Thank you.
Court calls the cases of the people versus Mario Crawford.
Good morning, Your Honor. Ronica Glenn on behalf of Mr. Crawford. Can you state your name for the record, please?
Mario Crawford, Your Honor. Thanks. What are we doing?
We would like to adjourn for sobriety court screening.
For sobriety court?
Yes,
How far are we along on that process?
that is a very good question.
It's a good question.
Yes.
I know. That's why I asked it. Who are you looking for?
Cannon.
Bishop, can you find Cannon?
She's right outside.
Miss Cannon? Mr. Crawford's just fine, but you left Miss Glenn up here without all of the information that apparently you may possess. What? What?
But it was Joy's fault.
Nothing is Joy's fault. Judge?
Stephanie Kane on behalf of Mr. Crawford. Your Honor, Mr. Crawford, I have been in touch with the staff. I think we've come up with a decent plan. There's paperwork that needs to be submitted that I have to get a signature on. He was supposed to have been screened for sobriety court. I didn't do that. It wasn't me, but now I know we're gonna get it done.
All right, how much time do we need to try to get all of that done so we can get Mr. Crawford's case moving along?
Your Honor, I'm gonna submit the paperwork today. I just need his signature in a couple of spots as it relates to that.
I mean, somebody's gonna have to make an assessment. Which sobriety court are we looking at?
Your Honor, I believe the one downtown would be better based on where he lives.
Got it. All right. Probable cause conference, I'll adjourn to April 30th, 2026, 9 a.m. Bond continued. Let's get it done.
Thank you.
Thank you, Your Honor.
Thank you, Mr. Crawford.
All right, that was it.
Court calls case People versus Tony Bailey. You got to keep moving.
Your Honor, Raymond Cook for the people.
And I'm acting on behalf of Mr. Bailey.
Your name, sir?
Tony Warren Bailey. How you doing?
I'm doing great.
Long time no see.
Been a minute.
It has. How you been?
You're doing great. You?
Probably
could be doing better. Otherwise, you wouldn't be here like this, right?
Exactly.
All right.
Exactly.
Your Honor, we're adjourning this matter. We're just waiting for some media to come in.
Sorry.
We're waiting for media to come in.
How soon is that going to be?
Your Honor, I reached out to the officer. They
Can we
indicated
video?
The video is cameras and that.
survey.
Thank you.
I bet this, so if they have it, they'll get to us quick.
Probable cause conference will be adjourned April 30th, 2026, 9 a.m.
Honor.
Bond continues. All right. Thank you, Mr. Bailey. Court calls case People versus David Grayson.
And the Overwater Assistant Prosecuting Attorney for the people.
Mr. Grayson. So I have names on this.
Yes, Your Honor. I apologize, Mr. Grayson. I did not hear your name being called. Good morning. Good morning, Your Honor. We are requesting an adjournment for Mr. Grayson. We and having reviewed our case file, we are in need of some additional discovery that we need to request from the prosecutor's office. I was just having Mr. Bishop and I were just in the process of doing the green sheet for Mr. Grayson, as you call it.
Made the green sheet. Can you state your name, please, sir?
David Richard Grayson.
Thank you. Probable cause conference will be adjourned to April 23rd, 2026, 9 a.m. Bond will can. Thank you, sir. Court calls case of the people versus Jeffrey Ball.
We're going to put the people.
Veronica Glenn on behalf of Mr. Wainwright. Oh my goodness. On behalf of Mr. Ball.
What's your name, sir?
Jeffrey Ball.
Thank you.
Your Honor, we would like to adjourn for mitigation.
How you doing?
For this.
How did that?
Probable cause April 30th, 2026, 9 a.m. Okay. Bond will continue. Thank you, sir.
Thank you, Your Honor.
Court calls case people versus Antonio Guy.
I'm ready to cook the people.
Veronica Glenn on behalf of Mr. Guyton. Can you state your name for the record, please?
Antonio Guyton.
Sir.
Your Honor, we would like to adjourn for mitigation.
This is the only case he's locked up on, or
This is the only case that we have.
only case that's holding you here, sir?
Washington County yet.
Pardon?
For Washington County yet.
You have other.
Yeah, I got something in Wayne probation.
Probable cause conference April 23rd, 2026, 9 a.m. Bond.
Thank you, Your Honor.
Thank you. Thank you, sir. Court calls case people versus Rashawn Bangora.
Yeah.
City attorney for the people.
Really? Where's Bukovich?
Spakovich. So, Your Honor.
Oh, there you are. It's okay. Thank you for listening to me. You don't know who I called, do you?
Is it Mr. Bangor?
It is.
At this time, Your Honor, we are requesting an adjournment for the purposes of obtaining outstanding video discovery.
All right. Bangor? Okay, there you are. You turned on your camera. State your name, sir.
Arshawn Bangor.
Will the 30th be enough time for you, sir?
I think so.
Sir, I'm going to adjourn your matter to April 30th.
All right.
2026, 9 a.m. Bond will continue.
All right, good looking, good looking. Yeah.
Thank you.
Doing the 2. I know I'm doing the 3. All
right. Court calls the case. People versus Derek Hurd.
Jacob Kennedy for the people, Your Honor.
May it please the court, George Lyons appearing